This is the podcast from the law firm Tavares y Oliveira Advogados Asociados, a space dedicated to discussing current and relevant topics, bringing together experts, insights, and analyses on how new laws impact the daily lives of individuals, businesses, and society, all delivered with a clear, ethical, and professional approach. In Episode 6, presented here in our English version, we cover global mobility and legal representation before the courts for companies and expatriates, the challenges of corporate immigration, the protection of rights, and the integration of global talent. We also highlight partnerships with global mobility firms, as well as immigration and corporate compliance. If you work in international mobility, global HR, or corporate immigration, or simply wish to better understand the challenges and opportunities in this landscape, this episode was created especially for you. The Tavares y Oliveira Advogados podcast is available on major platforms, including Amazon Music, Apple Podcasts, Deezer, Spotify, and YouTube. We hope you enjoy it. Happy listening. Be sure to subscribe to our channels and leave your comments.
Imagine for a second that you're this highly sought-after engineer. Let's say you're based in Munich.
Right, a real top-tier professional.
Exactly. And a massive multinational corporation recruits you to lead the development of a state-of-the-art electric vehicle battery plant right here in Brazil.
A multi-million-dollar project.
Yeah, massive stakes. And the Brazilian government, under its modern migration laws, they practically roll out the red carpet for you. They want your expertise.
They absolutely do.
So you pack up your life, you pull your kids out of school, say goodbye to friends, and you fly across the Atlantic. You arrive with all the right approvals, just, ready to build the future.
Yeah.
But then you hit a wall. Not a legal wall, a completely invisible administrative wall.
Oh, the administrative wall is very real.
Right, like an IT glitch at a local office or just a misfiled form by some understaffed department, and suddenly you are completely undocumented.
It's a nightmare scenario.
You can't sign a lease for an apartment. You can't open a local bank account. You're stuck in a hotel. Your company is bleeding cash waiting for you to start. And, you're trapped in this bureaucratic limbo. And there's no customer service line you can just call to fix it.
No, there really isn't.
Yeah.
And it's an incredibly stressful, isolating experience.
I can only imagine.
And the thing is, it happens far more often than people realize. You move from this high-stakes, hyper-efficient world of international business directly into the sluggish, unpredictable machinery of state bureaucracy.
And that massive disconnect is exactly what we're tackling today. So welcome to today's deep dive, where we are exploring the critical research and insights from Tavares y Oliveira Advogados Asociados.
It's a crucial topic for anyone in global mobility.
Definitely. Our mission today is to thoroughly map out the complex landscape of global mobility and judicial action for migratory regularity in Brazil. We are going to look at what happens when the welcoming spirit of a country clashes head-on with its operational systems.
Yeah, and how the right legal strategy protects not just massive corporate investments, but, basic human dignity.
Right. And to navigate all of this, we are drawing directly on the foundational expertise of Tavares y Souza de Oliveira. We're talking about someone with over 30 years of distinguished leadership across civil, family, and migratory law.
30 years gives you a very unique perspective.
It really does. What jumped out at me in the materials from Tavares y Oliveira Advogados Asociados is her core philosophy. It's this profound understanding that true legal excellence isn't just reciting codes. It has to be built on solid experience combined with a highly personalized, humanized approach to client care.
That holistic view is absolutely critical. I mean, when you spend 3 decades handling deeply personal areas like civil and family law alongside migratory law, your perspective shifts.
You see the human element more clearly.
Exactly. You stop seeing expatriates as merely, human resources on a spreadsheet.
Yeah.
You understand that behind every visa application is a real family in transition.
Yeah, kids trying to adapt to new schools.
Spouses putting their careers on hold. You realize an administrative bottleneck isn't just a bump in a business timeline. It's a profound disruption to someone's entire life.
Okay, let's unpack this. Because Brazil has genuinely evolved into a major global hub, right? It's a magnet for talent, investors, tech companies. And the catalyst for a lot of this is Law 13.445 from 2017, the migration law.
That's the legislative bedrock, yes.
Right. And on paper, this law was a complete paradigm shift. It moved the country away from that older 1980s mindset that viewed immigrants with suspicion and started recognizing them as vital contributors to the economy.
That is the legislative intent in a nutshell. It guarantees fundamental rights and sets a tone of integration. But, and this is the essential nuance that usually trips up global companies, the 2017 law is just the foundation.
Right.
The actual daily administrative routine that our engineer from Munich faces is governed by something else. In parallel to that law, you have Decree 9.199, also from 2017.
Okay, so secondary decree.
Exactly. That decree is the main secondary normative instrument in everyday use by immigration agencies.
Yeah.
And it goes even deeper than that.
How so?
Well, you have interministerial ordinances. You have normative resolutions from the CNIG, which is the National Immigration Council.
Yeah.
And you have specific, highly detailed administrative instructions from the federal police.
Wow, that is a lot of layers.
It is. All of these conform and shape the daily reality of immigration in a way that is incredibly determinative and rigid.
So if I'm understanding this institutional flow correctly, one of the biggest mistakes a company can make is treating all these government agencies as if they are just one big immigration office.
Oh, absolutely. It is a very common and very costly error.
Really?
Yeah, you absolutely cannot refer indiscriminately to the federal police and the Ministry of Justice as if they are interchangeable entities. They have completely distinct roles. Mixing them up will ruin your legal strategy.
Okay, let me test an analogy here. Tell me if I have this right. The Ministry of Justice is like the exclusive club promoter or the adjudicator.
Okay, I'm following.
They look at the broader policy. They analyze the legal merit of whether an investor qualifies for residence. They basically decide who gets on the VIP list. But the federal police, they are the bouncers at the door.
Right.
They don't make the policy. They handle the border control, the biometric data collection, and the actual physical printing of the registry document.
That is a very effective way to visualize it. The ministry handles the adjudication based on legal criteria, while the federal police is the frontline executor of those administrative acts. And this division of labor is exactly where the friction begins.
Because the VIP list gets approved by the ministry, but when the expatriate shows up to get their wristband, so to speak, their physical document from the federal police, the system just breaks down.
Exactly. What's fascinating here is the stark contrast between the modern, welcoming intentions of the migration legislation and the harsh reality of the state's operational capacity to execute it.
So it's like sending out glossy VIP invitations to the world's best talent. But when they arrive, there's only one disorganized security gate holding everyone up. I mean, why doesn't a welcoming law automatically translate to a smooth arrival process?
Well, it comes down to state infrastructure. A progressive law doesn't magically upgrade 20-year-old legacy IT systems.
That makes sense.
And it doesn't instantly multiply the number of trained public servants available to process complex international documents. So what you get on the ground is excessive bureaucratic sluggishness.
And actual denials too, right?
Yes. You see administrative denials that completely lack legal justification. An overwhelmed agent might misinterpret an obscure interministerial ordinance and just reject a petition.
Wow.
Yeah, completely ignoring the fundamental rights guaranteed by the main 2017 migration law.
So the individual and the company are totally stranded. If the administrative desk is basically an unplugged phone line, what does the judicial route look like? Are there specific levers you pull?
When the administrative road fails, the solution is to take effective action before the Brazilian judiciary. There are specific procedural remedies designed to protect the expatriate's fundamental right to freedom and dignity.
What kind of remedies are we talking about?
We are talking about possible legal instruments like the mandado de segurança, which is a writ of mandamus, the habeas data, and the ação ordinária, or ordinary action.
Okay, let's look at those. Mechanically, how does a mandado de segurança work? Does a judge just call up the police station and tell them to stamp the paper?
No, not at all. It operates on a much more structural level. A mandado de segurança is a possible tool used when a clear, undeniable legal right is being violated by a public authority.
Okay.
The lawyer drafts a petition showing exactly where the law guarantees the right and how the state is violating it. The judge then demands that the specific authority provide a legal justification. If they can't, the judge overrides the block.
And the other two? Habeas data and ação ordinária.
Habeas data is highly specific. It's focused entirely on ensuring the right to access or correct personal data held by the government.
Like an IT error linking a passport to the wrong file.
Exactly. It forces transparency. The assum ordinaria is a broader judicial action utilized when a case is highly complex and requires extensive production of evidence.
Now, we need to inject a serious dose of realism here, because I feel like in the corporate world, people might view a lawsuit like a magic wand. You file it, and the problem just vanishes.
We must be absolutely clear about this. That is a complete myth. These procedural remedies are possible instruments to unblock migratory bottlenecks, but they do not guarantee results or specific deadlines.
Right, it's not a fast pass.
Exactly. The judiciary has its own massive workload and complex rhythms. Filing an action demands rigorous legal review, but it does not mean the system suddenly bends to your corporate timeline.
I also want to clear up a rumor. Filing this action doesn't mean the individual public servant is hit with personal fines, right? And it doesn't mean they face criminal liability for disobedience.
That is a crucial distinction. The legal action challenges the administrative act of the state. It is against the authority in their official capacity. It is not a personal attack on a clerk.
Okay, good to know.
Yeah, and the financial penalties for noncompliance fall on the public treasury, not the employee. It's about holding the state accountable to its own laws.
Speaking of realistic approaches, an expatriate's life doesn't have to completely freeze during this process, right? Some assume you have to wait for the final physical card, the R&M, to do anything. But what about the taxpayer ID, the CPF?
Yes, another important myth. You do not have to wait for the R&M to get a CPF. A permanently valid CPF operates under its own distinct regulatory flow. It can be obtained independently of the final migratory registry card.
Okay, that's a relief for a lot of expats, I'm sure.
Definitely.
So we've established the administrative route is broken and the judicial route is complex. Here's where it gets really interesting. How do corporations actually execute these legal solutions safely?
Well, they have to construct a very specific governance model. When a global company moves talent to Brazil, they almost universally rely on a global mobility agency for logistics.
Right, the housing, the moving trucks, the travel agency for corporate expats.
Yes. But here is the legal restriction in Brazil that many foreign corporations miss. The capacity to postulate before the judiciary, meaning the right to draft petitions, file lawsuits, and provide formal legal consulting, is strictly restricted.
Restricted to who?
To lawyers and law firms formally registered with the OAB, the Brazilian Bar Association.
So even the biggest global mobility agency in the world cannot legally step into a Brazilian federal court.
Exactly. If they try to offer legal consulting, they are stepping entirely outside of their legal mandate. Therefore, the ideal governance model requires a strategic alliance.
A partnership.
Yes, a symbiotic partnership between the global mobility companies handling logistics and Brazilian law firms registered with the OAB handling the technical consulting and litigation.
It's like navigating a complex expedition. You absolutely need the travel agency to plan the logistics and book the flights. But the moment you reach the hazardous terrain of the Brazilian court system,
you absolutely need the localized license guide. You need the OAB registered law firm to safely navigate that environment.
and the research emphasizes that these OAB-registered law firms must remain completely autonomous and independent from the mobility companies. Why is that boundary so vital?
Because independence guarantees uncompromised legal judgment. The law firm isn't just pushing paperwork to meet an agency's quota. They provide specialized technical consulting and use strategic litigation to guarantee legal security and business continuity.
That makes total sense. It ensures you have licensed architects ready to build a judicial bridge over that administrative wall.
Precisely.
Well, we've covered a lot today. The welcoming philosophy of the 2017 law, the tangled reality of the secondary decrees, the possible procedural tools like the mandato de segurança, and the ideal corporate governance model.
It is a vast technical landscape. But if we connect this to the bigger picture, we have to look past the corporate governance models and the administrative routines.
What's the core takeaway?
What droll. Zenaide Souza de Oliveira's decades of experience ultimately teaches us is that migratory regularity isn't just about paperwork or business continuity.
Right.
It is a fundamental pillar of human dignity. It's the realization of the right to freedom for every human being. When someone is caught in an administrative void, they are stripped of their basic agency. Restoring that regularity through the justice system is about restoring their dignity.
That really reframes the whole conversation. It's a powerful reminder that the law is a tool to protect people.
Absolutely.
So what does this all mean for you? Consider this. In an increasingly borderless digital economy, how much human potential is currently trapped behind a delayed bureaucratic stamp? And what could society achieve if we viewed migratory regularity not as an administrative burden, but as a basic human right?
It's a question every global company needs to be asking.
It truly is. Thank you for joining us on this deep dive. If you want to understand how the law impacts both global business and human lives, we invite you to follow the Tavares y Oliveira Advogados Asociados podcast.
Yes, please do.
Make sure you subscribe on Spotify, Apple Podcasts, Amazon Music, Deezer, and YouTube so you never miss an update on navigating these critical legal landscapes. Until next time. This podcast is produced by the law firm Tavares y Oliveira Advogados Asociados, utilizing technological resources for research, organization, and content production, and is reviewed by its attorneys. The content is exclusively informational and educational. It does not constitute legal advice, guarantee of results, or legal guidance regarding specific cases in accordance with the Code of Ethics and Discipline of the Brazilian Bar Association.